Well, thanks very much for the warm welcome. That's update my bio on the website. Things have changed since I last put that up. But thank you very much, and thanks also for Meg for the wonderful invitation to come here and speak amongst such esteemed speakers we have over the next 2 days, today and tomorrow. As a Cullinan man with connection to the Mudugini, Coomera and the Gundari tribes, I'd like to acknowledge the traditional owners of the land on which we're meeting on today, the Tweed people, and I pay my respects to their elders past and present. As I do with all my presentations, I'd also like to take this opportunity to make a declaration that I do not condone acts of violence, mental or physical, against women and their children. Judge Jean Boyd, known as the Affluenza Judge, sentenced Ethan Couch, a 16-year-old white kid, on 10 December 2013 in Texas to 10-year probation and no jail time for running over and killing 4 people while drink driving with a blood alcohol level 3 times the legal limit. The case attracted international attention, partly because the psychiatrist testifying for the rich white teenager said he suffered from affluenza, which is not a recognised disorder. The same judge a year earlier sentenced a black 14-year-old to 10 years in prison after he threw a punch that resulted in another teen's death when he fell and hit his head on the pavement. In both cases, the black and white youths pleaded guilty. The outcome in sentencing for the youths from different racial origin by Judge Jean Boyd is clear for all to read. My paper today will demonstrate that you don't have to travel the land of the free, governed by a colourful, pardon the pun, man whose favourite word is fake news, to read about extraordinary judicial inequity involving race. Because judicial race bias is inexplicably a palpable daily occurrence that manifests itself in the imposing and nondescript courtrooms around this nation, but also as colourful characters of influence, most notably one with a mop of red hair who still insists she's Indigenous too. I'll make flippant references to these colourful political personalities because it is their ultra-right commentary that offers the anecdotal evidence to over-remunerated social commentators in print and electronic media, who in turn influence the gullible populace with a getting tussled in crime rhetoric that in turn suppresses news on the very thing that we all come here to discuss, the appalling rate of Indigenous incarceration. Australia's highest-ranked Indigenous public servant, Aboriginal and Torres Strait Islander Social Justice Commissioner Mick Gooda, lashed out at the Australian judicial system that enabled one of its judges to hand down a manifestly light sentence for a non-Indigenous Australian in a fatal crime committed against an Indigenous child. ABC News reported Matthew Alexander was given an 18-month suspended sentence and 6 months in home detention for the incident, which killed 8-year-old Indigenous boy Jack Salton Page in Darwin, that Mick Gooda said seemed to be light for the crime compared to what happens to our people. Daily reported Mick Gooda in reference to the ABS figures that revealed Indigenous Australians make up 86% of the NT in the adult prison population, saying it was hard to get away from making the conclusion that there appeared to be different laws applied to Indigenous and non-Indigenous people, especially given Alexander's sentence. James, reporting on the same tragic case, wrote that despite Alexander's sisters providing evidence that he was heavily affected by methamphetamine at the time of the accident in November 2014, Justice Stephen Southwood said he had taken into account the fact Alexander, 23, was still a young man with a good record and that he had clearly panicked and fled. A year on from the baffling judicial decision, NT Attorney General John Elferink was adamant the NT Department of Public Prosecution would not appeal the sentence. Clark, reporting on the case, quoted Elferink saying the DPP Director Jack Kaczewski, QC, found Justice Stephen Southwood's sentence to be fair. I asked the head of the DPP here to review whether or not the sentence was manifestly inadequate. The head of the DPP has indicated that he is disinclined to appeal it on the grounds the sentence was adequate in relation to the offence for which he was found guilty. Clark also reported Attorney General Elferink rejected Mick Gooda's claim of racial divide in judicial sentencing patterns of white and Aboriginal offenders when he said, "The justice system in the Northern Territory delivers its justice without fear or favour, and to assert that there is some racial motivation in relation on the part of the judge is something I do reject outright. One wonders the outcome if the 8-year-old boy killed in this accident was white and the driver was Aboriginal. Would the judge give an Aboriginal offender an 18-month suspended sentence and 6 months in home detention in a fatal hit-and-run crime committed against a white child riding his BMX bike on a suburban street?" To prove Justice Southwood's judicial faux pas was not in one way, was not a one-off. Northern Territory Aborigines, there was another sensational courtroom blunder 4 years earlier in the same city of Darwin, the city I now call home, this time by the jury, of a not guilty verdict of a Watch House Police auxiliary worker named Campbell, who was accused of acting inappropriately to Aboriginal women. Shane McDonald reported the jury took just over 30 minutes to reach the verdict on the 8th day of the trial. Mr. Campbell was accused of forcing 2 long grassers, homeless Aboriginal people who live in long grass on the outskirts of town, taken into protective custody last January for drunkenness to perform oral sex on him. He was alleged to have masturbated in front of the 3rd woman after she refused his request. CCTV footage used as evidence showed Mr. Campbell leading the women into the stairwell where it was alleged the incident took place. The court heard there was no surveillance inside the room. The jury decided the footage and inconsistent evidence given by the 3 women was not enough to convince Mr. Campbell, who was described by to convict Mr. Campbell, who were described by character witnesses during the week as friendly and respectful towards women. Why is the evidence of 3 witnesses not sufficient to gain a guilty verdict? Could it be that in this instance, the ethnicity of the witnesses and the fact that they resided at no fixed address might have influenced the jury? Even when Aboriginal people are not facing the threat of incarceration, they are confronted almost daily with media reports that to them show a criminal justice system that acts against them, not for them. Would the jury make the same ruling if the Watch House Police auxiliary worker was Aboriginal, who led 3 white homeless women or white women from a caravan park or a public housing address to perform oral sex on him inside the watch house? The Honourable Wayne Martin, Chief Justice of Western Australia, who, in his keynote address to the 2009 Australia and New Zealand Society of Criminology conference in Perth, attributed the overrepresentation of Indigenous people in the criminal justice system to a combination of changes in offending behaviour and changes in judicial behaviour, including denial of bail and greater use of imprisonment. Chief Justice Martin also attributed in his keynote address to the salient point that there is a real danger in this environment of sensational media coverage on acts of crime that both judges and politicians will take the view of the vocal minority as representative of the views of the majority. This extraordinary insight by Chief Justice Martin of the potential of his judicial colleagues to be affected by external influences gives rise to the following contentious question. Are judicial determinations involving Indigenous Australians tainted by subliminal bigotry? That has been my experience and is the daily experience of most members of my community, as it is with most Indigenous communities around the nation that I've called to come in contact with to speak on this matter. I don't talk of isolated instances of renegade judicial officers who lavish frightfully insensitive remarks or validation in their decision making when Indigenous people appear before them. I speak of about 80% of all magistrates and judges. The other 80%, some of whom I referred to, are present in this room today. I met 2 wonderful judicial officers at morning tea, fall into the category of people who understand our needs and aspirations, and to which I refer to as our supporters and advocates. The 80% of those with unsavoury dispositions to which I speak publicly in all my presentations are of an Australian majority cohort that I believe still long for a lifestyle of their forebears who knew how to manage their blacks, a term of redneck Australia that you can only see clearly when viewed through the lens of a First Nations person. To that regard, I speak of Magistrate John Neal's faux pas, reading of his notes in Darwin's Court 2 in the second day of a hearing charges against an Indigenous man of drunkenness and indecent exposure. And this is his note. Next saw Abo man, he said, adding, "Forgive me, that's my note." would lend some weight to this line of inquiry. It would appear Magistrate Neil wrote disparagingly of the accused in a case he was presiding over and casually used the descriptor Abo, knowing its offensiveness. However, it did not bother him writing about Abo in the comfort of his chamber, and only had cause to allude to an oversight, not an apology, for his faux pas, in this instance inside a courtroom setting where journalists were recording his considered words. Justice John Dowsett, one of the three presiding judges hearing my appeal on the full bench of the Federal Court in Hagan versus the Toowoomba Sportswear Trust, 2001, in his paper, Prejudice, the Judicial Virus, opined, recognition that a judgment may be infected by prejudice is not new, nor is such recognition an insight that is peculiar to lawyers or judges. Society has been aware of the risk for as long as we have been judging one another. With those strong sentiments in his views that a judge will not be aware of how he or her own background is shaped and continues to shape views, attitudes and conduct, Justice Dowsett and his peers knowingly or inadvertently continue to imprison Indigenous offenders at a disproportionate rate to non-Indigenous offenders. Roberts, in the same vein, contends that judges are not entirely impervious to the tide of popular and professional opinion, and these forces alone may have influenced the extent to which judges use imprisonment as a sanction for Aboriginal offenders. Government of all persuasions, on heeding the message of community expectation for them to be tougher on crime, are unduly influencing the rising tide of Indigenous offenders gaining custodial sentences as opposed to the option of bail, while white offenders continue to be treated leniently. Steeles and Goulding argue that when it comes to crime and community safety, as it relates to Indigenous Australians, Australia's mainstream conversation generally adopts the line of talking tough on crime. Despite the tendency by civic leaders to blame Aboriginal people for the vast majority in rural communities, Jobs and Donamaya et al. Assert that lower class whites are also a problem that should not be underestimated. Indigenous Australians are impacted by whiteness in every facet of our daily lives as we participate in a society not of our making, under conditions not of our choosing. That is whiteness in action, as I know it, as experienced by my father and his father before him, and as witnessed without complaint by his mother Trella all those years ago. Alcoff contends whiteness was an idea that was promoted, yes, but it had to be shaped by those who ascribed to it to fit their own experiences and understanding. The unfavourable treatment of members of the judiciary to First Nation people to fit their own experience and understanding has a history of white boat people's arrival on our land back in 1788. To disguise the theft of land from our ancestors, the boat people and their descendants wrote their own version of history of lawful settlement of an empty land through the legal doctrine of terra nullius, to then morph from an identifiable British diaspora status on stolen land to a more favourable self-acclaimed sovereign proprietorship title. A rapidly expanding white Australian conveniently and expeditiously used whatever means available to control those million plus people of a black skin who are on their empty land. Over 220 years of occupation, the white population passed on through the generations the means to hold sway over those black people who somehow appeared on their land at first contact, through the power of the gun and liberal usage of poison initially, to more sophisticated yet destructive means through the media and politicians in collusion with the judiciary soon after settlement. African American novelist James Baldwin, in putting his case forward that there is no such thing as whiteness, or for that matter blackness, more generally race, argues, no one is white before he or she came to America. It took generations and a vast amount of coercion before this became a white country. In his provocative reasoning, Baldwin challenged his readers to examine the very nature of the construction of the systems of privilege and oppression, which sociologists call the social construction of reality. Lipps argues that there is more to whiteness than just attitude. The possessive investment in whiteness is about assets as well as attitudes. It's about property as well as pigment. It does not stem primarily from personal acts of prejudice by individuals, but from shared social structures that skew access to resources, opportunities, and life chances along racial lines. I still have evocative childhood memories from my humble beginnings being raised by displaced traditional owner parents on a fringe camp situated politically and strategically by civic leaders between the sewage treatment works and the town cemetery in the segregated rural community of Cunnamulla in southwest Queensland in the late 1950s and throughout the 1960s. These civic leaders had shared social structures that facilitated racist bylaws to support their privileged vantage point of locating the blacks out of sight, out of mind, on the least desirable parcels of land. Atkinson, Taylor et al. Argue socio-economic exclusion and political marginalisation of Indigenous Australian life continues in large part because it is out of sight of white Australia. I am cognizant that I still carry the invisible scars today of the evil disconnect of normalised whiteness that immersed Cunnamulla's non-Aboriginal population of that era. To understand my pain back then and to which I still carry today, I have to go back even further. It is that high level of apathy towards first Australians that is part of white Australia's DNA, from stories passed on through the generation of how we kept the blacks under control. That still resonates in the uncaring attitude of many, certainly not all, non-Indigenous Australians today. Roberts wrote of the appalling conditions of Trella, my great-grandmother's era, which they were subject to back then. On cattle stations, the Aboriginal women is usually at the mercy of anybody, from among the white staff and locked up at night to keep women from their own people. In 1900, a station owned by the Queensland National Bank had 8 or 9 gins fenced in with rabbit-proof netting next to the house. One man sent a gin away with the mailman to Burketown to be sent south to some of his friends as a slave. Parties of men used to go out to capture gins. These women were traded between stations. The government report in 1900 states that the women were handed around from station to station until discarded to rot away with venereal disease. The Aborigines fiercely resisted this slave trade. A magistrate reported every murder that occurred on the coast was due to the carrying off of gins. And a select committee was told, in the matter of kidnapping gins, you cannot control white men. And it is because of half the murders committed by the blacks upon them. A correspondent in the North West Times wrote in 1894 that whips used for flogging only wipe the dust off a native. Flogging is all very well in its way, he observed, but a nigger can take a power of it to convince him. I am cognizant of the era of this newspaper's publication, 1894, 12 months before my grandfather Albert was born. A fear for the palpable loathing he and his people were held by settlers broadly and pastorals specifically immersed in whiteness at the time of our shared history. In a nation that incarcerates its First Nation peoples at a shamefully higher rate per head of population compared to its non-Indigenous population, including the astonishing jailing of black men 5 times more than apartheid South Africa in a bygone era, it is refreshing to hear, however, of judges who advocate to reverse the vicious cycle. If only the exception of caring judges making a difference in reducing Indigenous incarceration rates and recidivism was the rule for judges in Australia, there would be no need for a conflict like this one to take place. The poignant comment by Judge Michael Ford about Indigenous community leaders working to address issues of law and order, which will not work unless there is government will and financial support to ensure they succeed, is apt. The District Court judge made those informed observations after spending years working in courts servicing remote communities in the Gulf of Carpentaria, where he spent years on a personal campaign to demolish a cultural belief among young Aborigines in remote communities that going to jail is a rite of passage on a path to manhood. Martin, reporting for ABC News, quoted West Australia's Chief Justice Wayne Martin in response to an Amnesty International report that claimed Western Australian Aboriginal children are 53 times more likely to be jailed than their peers, saying the justice system must accept some of the blame for what he describes appalling Aboriginal incarceration rates. The justice system applies rules that work very well for conventional or mainstream Australians. He said, they don't work terribly well for people who are marginalised and disadvantaged. Herein lies the problem of a judicial system that, in the main, is too rigid in its dealing with Indigenous Australians and steadfast in its resolve to enforce breaches of societal codes of conduct. Aboriginal and Torres Strait Islander Social Justice Commissioner McGooda, in his forward A Brighter Tomorrow, Keeping Indigenous Kids in the Community and Out of Detention Australian report, identify how the ongoing legacy of colonisation and everyday experience of racism of our people cannot be overlooked as contributing factors to the high rate of Indigenous incarceration. I've got 5 minute wind up, so I'll fast track my paper, but I'm sure it'll be available online. It's a little more voluminous than I thought. In 2010, Queensland Judge Michael O'Driscoll dismissed a case against a Gold Coast pensioner, Dennis Mulheron, for using the terms nigger and sand nigger in an offensive fax to a local politician. Roach reported O'Driscoll's ruling that the words used were crude, unattractive and direct, but were not offensive to a reasonable person. So here is a judge who assumes a reasonable person is a white person, and that white people, because they have not been subjected to racial abuse, do not find it offensive. This is whiteness, the privilege of growing up without a racial identity or being discriminated as a causal effect of exposed in its xenophobic embodiment. Glenn Norris reported problems within the Queensland judicial representatives being out of touch with the average Queenslander, and the reason Attorney General Yvette Duff is considering appointing an independent watchdog to handle complaints against the judiciary following a spate of controversial decisions. Right or wrongly, it is a common complaint that judges and magistrates are out of touch with the rest of the community, that their sentencing does not reflect the average person's concern about safety and welfare. The upper echelon of the law, I'll just move clearly on that, the clock is ticking, but Gittins contends it costs the taxpayers $275 per day, or approximately $100,000 a year, to keep an adult in jail. And even more astounding is the cost of incarcerating Aboriginal adult prisoners. Aborigines make up 3.3% of the Australian adult population, but account for 26% of all adult Australian prisoners. In the Northern Territory, it is 86% of all inmates. If you want me to give you some economic reason we should care about this, it's not hard. On average, it costs $275 a day to keep an adult in jail, so it's costing taxpayers around $800 million. If you're using the Prime Minister's figures or Bill Shorten's figures, they could easily blow it to $1 billion a year just to keep that many Aborigines in prison. To answer my vexed question of impartiality in my particular experience with judiciary, I've taken a quote from one of the leading experts in Indigenous prisons in Australia, Weatherburn Holmes, who proposed 4 possible reasons for Indigenous racists of entry into prisons. And most of you already know that, you've probably read his stuff, so the last bit and I will say that the Indigenous offenders may be more likely than non-Indigenous offenders to be imprisoned if convicted, more likely to be convicted if charged with a criminal offence, more likely to be refused bail, more likely to be refused bail if charged with criminal offence, more likely to be charged with criminal offences. So I'd like, in conclusion, if you could all consider the prophetic words of Jane Baldwin, a brilliant African-American writer who I mentioned earlier, who experienced the worst that America had to offer in the area of racial relations and social justice. If one really wants to see how justice is administered in a country, one does not question the policemen, the lawyers, the judges, or the protected members of the middle class. One goes to the unprotected, those precisely who need the law's protection most, and listen to their testimony. So to conclude my presentation today, I'd like you all to close your eyes. Not a very hard thing, just pull your little eyelids down and close them. I'd like you all to close your eyes and think of those powerful words of Jane Baldwin, and think of a number between 0 and 10 as you answer to the following question. If you were to judge a country by how it treated its most disadvantaged, especially our incarcerated First Nation people, what number would your measurement barometer offer on a calibrated system of 0 to 10? Open your eyes and don't tell anyone your answer. But remember it and the reason you've arrived at that number. Over dinner tonight or back home with your family, I ask that you share it with the person sitting next to you and tell them why you came up with that number. Thank you.